All right. Well, welcome everyone. We are glad to have you join us today hello, Nancy. Glad to meet you. I wanted to welcome you all. We're glad to have you join us today as we take a cross-cultural and cross-country look at domestic violence, the persistent barrier to women's enjoyment across the world. So today I'm going to keep my introduction brief. Give me just a moment. I'm going to keep my introduction brief so that we can hear from the abundance of global experts on this topic, experts whose work is both academic and scholarly and grounded in lived experience and practice. To start, we want to make sure that everybody's aware that we'll be recording this event and may post segments of it, all or in part, on public domains. We do want you to be able to decide whether or not you want your words or image public, so we're letting you know in advance. Feel free to turn off your cameras or change your screen name for anonymity. My name is Denise Labertu of Women Lead Network and faculty at the California State University, Northridge, in the Criminology and Justice Studies Department. Women Lead Network is a collective of women who work to ensure that women's needs are central in discussions about world problems and that they're engaged as leaders in solutions to those problems. This includes all who identify as women, as well as femme, gender non-binary, and other birthing folks. Women Lead Network is sponsoring today's event. I want to recognize for the faculty in the United States that we've built our lives and homes on the unceded territory of Indigenous peoples and acknowledge their elders, past, present, and emerging, recognizing that the first peoples of the land are still here and are committed to lifting up their stories, culture, and community. Today, I'm joined by my colleagues in the United States, Kimberly Wong and Reena Patel. We'll review a variety of approaches to addressing domestic violence in the United States, including moving beyond trauma-informed into nurturing resiliency, approaches to addressing domestic violence that include legal structures and alternatives, and the impact of domestic violence on Indian immigrant communities living in the United States. We'll be joined by legal scholars in India who will provide an overview of the work they're doing on the ground in communities throughout the region to understand the implications of domestic violence in India and develop solutions that promote offender accountability and survivor autonomy. And we'll close with student scholars from California State University Northridge's Department of Criminology and Justice Studies, sharing their work using a human rights framework to reveal the implications of domestic violence for vulnerable groups. Chandra Mohanty, in her book Feminism Without Borders, speaks of her work as imagined community. She uses this language because it suggests potential alliances and collaborations across divisive boundaries and the idea of horizontal comradeship. She also reminds us that building a transnational feminist practice requires solidarities across divisions of place, identity, class, work, belief, and so on. We welcome you into this imagined community as we practice solidarity across divisions, and we hope that you continue to consider your work in this context. So I'd like to now turn your attention to the work of our colleagues and scholars from India, Professor Suman, Professor Arushika, and Agna. Are you ready to begin?
Thank you, Professor Denise. Thank you very much for that warm welcome. And it's indeed a pleasure to join from India on this platform, which, provides meaning to lives of women across the world. And it's indeed an opportunity today for us to talk about the Indian scenario in terms of where we stand, when we talk of women's rights, women's experience with the promise that was made by the Indian Constitution and women's experience of the law, the legal system, and their journeys as Indians, as equal citizens of India in general. Um, so, a very good morning to everyone who's joining in from America, and I hope that we'll be able to share to the to the uh, to the maximum extent possible our experience and our work with victims of domestic violence. It's indeed a great responsibility for us to discharge as we bring their stories today on this platform. On this note, let me start by talking a little bit about how the idea of domestic violence emerged in the Indian context. As we all know, the Indian national movement has carved a place for itself across the globe. And to those of us who have followed the history of the Indian national movement, we must have at some point of time heard of a term called ahimsa or nonviolence. The Indian national movement was built on the pillar of ahimsa and satya. Satya translates into truth, and ahimsa translates into nonviolence. And as a reputed scholar has remarked, the idea of violence and the definition of violence, therefore, should not have been very difficult for Indians to coin, because we have experienced violence over a period of time, and we have built our philosophy of freeing the country from slavery, from years of exploitation, on the idea of nonviolence. Yet, the very first time we defined violence in the Indian context was in the year 2005. I just want to make sure at this point that I'm audible to everyone. Professor Denise,
You
Agna.
are audible and we can see your screens. Thank you.
Okay. Thank you. Thank you. Thank you, Professor Denise. So, so as I was saying, the definition of violence came much later into the lexicon of Indian criminal laws and civil laws, even for that matter, especially in on the domestic front. The Indian Constitution came into force in the year 1950. And along with it came the idea of equality. So we have a chapter 3, which talks about fundamental rights. And one of the fundamental rights that's promised to all citizens is under Article 14. That is right to equality, equality before the law, and equal protection of the law. So the state is duty bound to protect this constitutional promise. And along with Article 14, we also have Article 15. The day the Indian Constitution came into force, the constitution makers and the state in general promised to all its people that for the sake of equality, we will have to make some special laws for those sections of society, for those communities who aren't part of mainstream society. So with them came women, children, senior citizens, people belonging to backward communities, socially and educationally backward communities, so on and so forth. So gender and sex were not to be a barrier in the enforcement of the fundamental right of equality. And that is the promise that was made by the Indian Constitution when it came into force in 1950. And 33 years later, so more than 3 decades later, however, we started talking about domestic violence for the first time. And this is important because um, even though we made the constitutional promise to all sections of society, irrespective of caste, creed, sex, and religion, the promise to equality was made to every person living in India. Domestic violence as a problem was recognized only in the year 1983, when, by an amendment, the Indian Penal Code, um, uh, was inscribed with Section 498, capital A, and along with that, we had another section in the Indian Penal Code, which was for 304, capital B. One of them, 498, capital A, talked about matrimonial cruelty and punished any willful cruel conduct on the part of the husband or the relatives of the husband against the wife in the matrimonial home, whether that cruelty was in the form of physical cruelty or in the form of mental cruelty. Of course, there were parameters set considering that it was a criminal piece of legislation. For example, gravity was an important parameter. Not every act of cruelty could be treated as a crime under the Indian Penal Code. And it could be treated as a crime only when the act, the willful conduct on the part of the husband or relatives of the husband was very grave. The question is, how grave does cruelty have to be then at that, under 498, capital A? Well, the law itself said that when it caused grave injury to the life or limb of the wife, or it it caused grave mental cruelty, leading to the woman, attempting to commit suicide or committing suicide per se, or when it was cruelty which was inflicted on the woman for dowry, then it would be considered as matrimonial cruelty as a crime under Section 498, capital A. 304, capital B was premised on the idea of dowry death. So it is in this context that I must state the history of these two legislations and the social reality that ultimately led to the amendments to the Indian Penal Code, to the then Indian Penal Code. As I think it's pertinent for me to point out that recently the Indian Penal Code has undergone massive amendments. It was replaced by a new code, which is called the Bharatiya Nyaya Samhita. So if you translate it, it would mean Indian Law Compendium. So we have retained dowry death and matrimonial cruelty as concepts in their original forms, but the section numbers have changed. But what's important for us to understand here is that a very grim social reality was responsible for the insertion of the concepts of matrimonial cruelty and dowry death. The social reality was the massive number of deaths occurring in India in the Indian kitchens, a phenomenon which was known to the Western world as bride burning. So bride burning is something that we're not proud of as Indians, of course, but it's something that we live with. It's an experience that that every woman growing up in India uh, has heard about, has known about, or has unfortunately, known either a neighbor to have, in the sense that it has known it either actively or passively, directly or indirectly, in one way or another. So with so many women dying in Indian kitchens, usually the trend of the deaths and the manner in which the deaths were happening in the 1980s, the peak period was late 1970s and early 1980s, which led to the legislation in 1983. Now, there was a common pattern in each of these deaths. Women were dying in Indian kitchens. Usually, the cause of death was said to be a stove burst, and the bursting of the stove there was no known factor behind it. The woman would be usually wearing a sari, which would be a polyester sari, which is highly inflammable. I mean, which could catch fire very quickly. And forensics would always never be able to come to the conclusion as to what led to the death of the woman. But very few days after the death of the woman, the man would undergo a second marriage. And this is a phenomenon that was happening all over India. It's not like there was a state or there was a part of India which was immune from this problem. Added to this was the problem of female feticide, which arose from the fact that being parents to a girl child in India meant that one's financial condition would be depleted, one's finances would be depleted in raising the girl child and in getting her married. So, and the financial investment would also usually not be a promise of her safety. So parents chose to kill the girl child even before she was born. Female feticide continues to be a problem in India, as does child marriage, despite legislations, being despite there being legislations to contradict to deal with these problems, to prohibit and prevent these problems. So as we can see, the circle is a very vicious one. There is a social expectation that women should be getting married at an early age. Marriage is mandatory for a woman. And usually dowry is not a problem because the woman would be walking into somebody's family and there would be expenditure in the growth in the fact that the family into which she would be marrying would be expanding. Women would not have financial independence because it's important for women to contribute to the social growth of the family that they're marrying into, and not to its economic growth by being financially independent. And how much dowry would one get would determine the status of the groom, as it would determine the status of the bride. So this is quite intricately woven into the idea that a girl child would then be perceived as a massive burden on the family. So it is in this context that the legislations, the anti-domestic violence legislations in India came into existence in the first place. And then in the year 2005, when we experienced that the criminal law was not enough to handle the problem of domestic violence, India came up with a very novel piece of legislation, which is called the Protection of Women from Domestic Violence Act, or the DV Act in short. Now, the 2005 DV Act was several steps ahead of the 1983 legislation because it provided women with very real remedies, women who were victims of domestic violence with very real remedies. For instance, um, the only thing that the 1983 legislation could do was to put the husband behind bars. But putting the husband behind bars wouldn't solve many problems in the lives of the woman. For example, many Indian women were dependent on their husbands for finances, for economic growth, for meeting the needs of the family in general. Likewise, women would have wanted a reconciliation at some point, so they would be willing to sacrifice almost anything and everything in order to be with their husbands under the same roof. So the 2005 legislation, that is the DV Act, came up with very novel remedies, such as residence orders or protection orders. So these were beneficial for many women victims, but the effective enforcement of the law became a problem because of many institutional barriers. Now, that said, I think it's important for me to point out that from 1983 to 2005 to today in the year 2026, the state has shown very pronounced reticence in admitting and recognizing domestic violence as a problem in itself. Now, I think it's time for us to talk a little bit about statistics at this point. So there are two important reports and data that we deal with, data sources that we deal with or rely upon whenever we talk about domestic violence. One is, of course, the National Crime Records Bureau, or the NCRB, and the other is the National Family Health Survey, or the NFHS. Now, the two data sources need to be read together in order to understand what the data looks like. So, if you look at the National Crime Records Bureau, it tells us that very few cases of domestic violence are actually registered with the police. But if you look at the National Family Health Survey, it tells us that more than 65% of women annually suffer from domestic violence. That number might increase and might decrease over a period of time and over a phase of 5 years. But women in the reproductive age group, on an average, admit to having faced some form of violence in their marriage. Now, Indira Jaisingh and Flavia Agnes are two feminists who write a great deal on domestic violence and statistics on domestic violence and the interpretation of domestic violence by courts. They write very frequently on various aspects of domestic violence. So, if we look at the analysis made by feminist scholars in India, we find that the NCRB data doesn't always correspond to the reality that the NFHS data exposes. Now, NCRB and NFHS are two different data points, data sources, but NFHS is the one which can tell us how many women in the reproductive age group might be facing violence or actually do face violence on the family front. Now, that's because this data depends on the records of hospitals. So, hospital records show or depict that women in the reproductive age group go to hospitals and visit doctors with complaints of a broken limb, a broken jaw, or one physical problem or the other, which is related to some sort of some sort of physical violence that they might have faced. And because it's a health survey, um, the data focuses only around those women who might have visited hospitals or might have visited doctors. So this data tells us that women, 60 to 65% of women generally, and that number might be much more or much less, in a certain year, but usually it's the average would be 60 to 65% women in India face violence in the reproductive age group inside their homes. And this violence is from their intimate partners, either because they are in a live-in relationship or because they face this violence from their husbands. The NCRB data, or the National Crime Records Bureau data, however, relies more on the cases that are filed, and a comparison of the two data sources reveals that while majority of women might face domestic violence, a minuscule portion of these women, very few women, actually approach police stations with complaints of domestic violence. So at National Law University, Odisha, actually we have been working for the last 3 years across 30 districts of Odisha to identify, among other things, why women are reticent, why women have difficulties in triggering criminal or criminal justice mechanisms when they are beaten black and blue by their husbands, or when they are abused by their husbands sexually, physically, emotionally, economically, or in any other manner. There are cases, many cases, of women in India where domestic violence seems to be the genesis of what comes in later in the form of homicide. So even as law teachers, when we teach students in the classroom, we look at, for example, when we teach criminal law, there are many cases in criminal law which are actually just homicide cases or murder cases, which are taught to students in the classroom as homicide cases. But when you dig deeper, these are cases of domestic violence which were not really curbed at the right time, and therefore they escalated into cases of homicide. So, for instance, if you look at a very famous Indian case, the very famous Indian case of Swami Shraddhanand versus Union of India. Now, usually it is taught as a case of murder, okay? But it's the husband who has murdered the wife in this case. The case of Ravi Kumar versus Karnataka, again something which is taught as a case of murder in, to examine whether the act amounts as murder or not, or whether a certain exception should apply or should not apply. In this case, we usually look at it from that perspective. But if you dig deeper, it's a case where the husband has again murdered the wife, and the Supreme Court thinks it fit to reduce the sentence or to reduce the degree of the offense by saying that it's okay for a husband to lose his temper at his wife when she disagrees with him. And when the husband loses his cool, it might so happen that he might put his wife on fire, and therefore it's a loss of self-control, and the law must bring the penalty, must bring the degree of the offense down from murder to down to culpable homicide. So the court's approach towards domestic violence as a problem is also very, very lenient, as one can, see. In one of her articles, noted lawyer, feminist, and the one who was responsible for the drafting of the Domestic Violence Act, Indira Jaisingh, who is the founder of an organization by the name of Lawyers Collective. She mentions that the Indian scenario in terms of dealing with victims of domestic violence is such that there is concern for the dead and condemnation for the living victims. So, why is there concern for the dead? Because courts are courts, of course, have greater ease in convicting the accused if the woman is dead in a certain case. So, if there's a 304 capital B case vis-a-vis a 498 capital A case, there is greater likelihood for a conviction under 304 capital B case, because 304 capital B deals with dowry homicides, or the murder of a woman. So here the dead body of the woman is the final proof that the court has. So there is some sort of sympathy that perhaps courts feel towards these women, and therefore the conviction might be easier because of this reason. But if you look on the other hand, if you look at women who are victims of matrimonial violence, and might have been, and these are women who, as Flavia Agnes puts very straight, it's these are women who have been raped by their husbands. These are women who might have been singed, who might have been cut, who might have been, physically assaulted by their by in a manner that they might have been disabled for their whole lives. Yet when they come to courts with cases of 498A, claiming that they should get some justice under the law for being violated by their husbands in matrimonial relationships, usually the approach of the court is to acquit them. These acquittals then add up, and when you look at these cases, I think some of these cases we have on the slides here, and maybe I'll show you how what are these judgments that we are talking about, and why we have problems with these kinds of judgments. But if you look at these judgments, you'll see that if the victim is alive, there is greater likelihood for the court to acquit the accused, and leave the victim in a state of great confusion and utmost disaster. So, by way of example, let me share with you the case of Mangatram versus State of Haryana. It's a 2014 judgment, and as you can see, I've titled it as "The Evidence We Can't Weigh." This is a case where a woman commits suicide because she wasn't able to take the torture of her parents-in-law and her husband. Now, for those of you who may not be very acquainted with the social realities of India, I would like to state that most of the marriages in India are very local or patrilocal marriages. That is, the woman marries into the family of the husband. So it's very common among Indians for married women, to stay with their husbands and the family members of the husbands. Actually, that was one of the reasons why 498 capital A, or matrimonial cruelty as an idea, was imagined of or conceived of in the first place. So these are the contents of a letter. Now, this is a case where the woman is dead. She commits suicide, and we don't know if it's suicide or murder, but there are claims by the prosecution that it's a case of murder, or that it's a case where a woman was driven to commit suicide. But definitely it's not that one fine day the woman just goes and commits suicide, and the parents-in-law and the husband didn't have any role to play. But when you look at the only evidence that was retrieved, it says, the letter read something like this: "But you should come. It is very important work. If you will not come on 25th or 26th, then I'll give my life. Therefore, both of you should come. Even if Somnath Mama will say no for you to go to Baroda, but both of you should come. It is important work. If you don't come, your daughter will give her life. What more should I write? You're wise enough. If there's any mistake in the letter, then forgive me." Okay, and she keeps on calling her parents to to come to her, because and it's the state of Haryana um, uh, where like other Indian states such as Odisha and many other states, it's very common for women to be abused in their matrimonial homes over dowry and over things like that. So here, the prosecution also claims that the woman was abused by her parents-in-law, and of course, the court looks into these matters, but says that the evidence that we have retrieved is not sufficient to hold a person accountable under 498A. So while it's one thing to it's one thing to state that you're not okay with admitting the evidence which is, or that it's not sufficient, we often lose perspective of the fact that that could be that's the that when an offense happens on the domestic front in the privacy of the home, this is perhaps the only evidence that one can retrieve. So Mangatram is just an example. There are many other cases. There's a very infamous case of Arvind versus state of Bihar, where a woman is murdered in broad daylight. She is burnt alive. Her family members are not informed about it. The High Court and the trial court both convict the accused of matrimonial cruelty, and still the Supreme Court deems it fit to acquit the accused, because they feel that not taking a burning woman to a doctor is not enough evidence, or not getting the police or not informing the parents of the woman is not cruel conduct on the part of the husband. So there are many interpretations and many ways in which courts have interpreted the idea of domestic violence and the idea of cruelty. What amounts to cruelty is a very fact-based interpretation. So there have been judgments where courts have gone to the extent of saying that if a family um, asks for money from the bride's family, if the husband's family asks for money from the bride's family for meeting financial stringency, then that is not dowry. Now, so it's almost like allowing backdoor ideas of dowry and indirect giving and taking of dowry, allowing this sort of taking and giving of dowry to be legal, or permitting it in so what I perhaps want to put across is that many of these judgments are bereft of the context in which the crimes occur. So you have women dying, you have women committing suicide, you have women being murdered in broad daylight without their family members being informed about these women, suffering because of the burn injuries, and without a doctor being available, with no investigation happening. Yet the courts deem it fit to suggest that these are not women who are being violated. And to add insult to injury, you have cases like Preeti Gupta versus Union of India, state of Jharkhand, where the Supreme Court calls these women as disgruntled women who misuse or abuse the law to unleash legal terrorism on innocent husbands. Now, that's the language of the court, and that's why I'm quoting quoting it. Then you have judgments which say that introducing constitutional law into family law, into the family, is like introducing a bull into a china shop. Now that's a big thing to say. It's almost like saying that because marriages are private institutions, because marriages are private relationships, the state has nothing to do, even if the wife is injured by the husband. So the very fact that we formulated a law for addressing the problem of domestic violence is reflective of the social reality that women in India are not equal in their homes. Women in India are facing a lot of abuse, a lot of inequalities on the home front. And when women are not equal to men on the home front, there are chances, there are more chances of them being violated in public. And to kind of explain this better, I would like to draw your attention to uh, one of the gravest crimes which India has been experiencing in the last few months. And that's the Arjikar incident, where a medical student raped by was raped while she was doing her duties as a doctor at night, and was resting when she was um, raped by a man. And the accused, when you look at the criminal profile of the accused, you realize that he had several pending cases of domestic violence, um, which were filed by his former wives, not one but two wives, against him in at the police station. What I perhaps mean to say is that when you forgive domestic violence inside homes, you also enable the accused and morally encourage him to commit bigger crimes in public. So perhaps arresting him when there were complaints of domestic violence would have been some sort of rigor, would have been some sort of kind of a disincentive for him to commit bigger crimes. It's like we say, it's like the broken windows theory. Um, Something like saying that if you allow pickpocketing to happen, if you allow small street crimes to happen, then obviously you will have to deal with the hazard of armed robberies, of big time thefts, and bigger, offenses. So it's like saying that if you want women to be protected from bigger offenses like rape, then you will have to stop eve teasing. You'll have to stop stalking, and that's something that we talk about whenever we talk about the broken windows theory, whenever we talk about addressing the problems of crime. But when we forgive domestic violence, stating marriage as some sort of a legitimizing factor for the perpetration of violence against women by their intimate partners, we also condone the bigger offenses. We also make space for the commission of bigger offenses, and I think that is a massive problem. So currently in India, we are on the verge of you know of of a social movement strong enough to, um, perhaps not strong enough at the moment, but very quickly gaining momentum, very quickly gaining strength, um, very quickly gaining strength in the on the sorry, I was a little distracted because of the question. Perhaps we're having two or three questions here. Okay, yeah, I'll be addressing this, Nancy. Ma'am, I'll be addressing this once I complete my presentation, if that's okay. So, yeah. So, yeah, perhaps what I was trying to point out is that every time we permit domestic violence to happen, we are making space for bigger offenses in the public, and we try to tell them that, well, domestic violence is a smaller problem and therefore it should be ignored. So yeah, I was saying that the movement, the movement for withdrawing anti-domestic violence legislation is very quickly gaining momentum in India. Um, it's not it's not as strong as one would have expected it to be at the moment, but there are very strong decisions of the Supreme Court. And there was also the 243rd Law Commission report, which talked about treating domestic violence as not so serious a problem. And today it's a cognizable offense. But the 243rd Law Commission report also stated that there's no reason why domestic violence should be a serious cognizable offense. Not just that, you would be astonished to know that in the year 2018, there was a judgment delivered, 2017, there was a judgment delivered by the Supreme Court, which was Rajesh Sharma versus State of Uttar Pradesh, where they called for the creation of certain committees, like they were called family welfare committees, for um, for kind of mediating, or kind of listening to the victim and trying to patch the victim up with her abuser. And if that didn't succeed, only then those filtered out cases would be eligible for a prosecution, for a criminal prosecution. Thankfully, that judgment was that portion of the judgment was struck off, and family welfare committees do not exist anymore. But to think of it, it was quite a shock for all of us, because these are non-compoundable, non-bailable, cognizable offenses that we are talking about. So these are very serious offenses, and the fundamental tenet of criminal law is that you cannot really go for an out of court settlement in offenses as serious as domestic violence or 498A, 304B. So the idea of reconciliation doesn't exist. So on this note, I think I would like to sign off by saying and a little bit also about how we are dealing with the current kind of backlash against DV legislations, anti-DV legislations. We're dealing with it by constantly criticizing the method of decision making in these cases. So, studies suggest that the grounds for acquittals are usually lack of evidence, but we also question um, how the principle of beyond any reasonable doubt should be interpreted in cases of DV, and what kinds of evidence one should expect and should not expect in cases of DV. So we do have institutional structures, but here at NLO we are trying to look for the creation of a model protocol which will be of use to victims when they approach a police station, because currently there's a lot of confusion about what is to be how a victim should be what path should be shown to a victim, and what processes should be triggered by the victim for her to get justice. So a lot of confusion remains in that on that front, but the silver lining is that we are still working very hard. Feminists in India are still working very hard to mellow down the voice of organizations and men's movements, which are kind of denouncing and generating adverse propaganda against anti-DV legislations, and trying to say that women now are very educated and very liberated, and therefore they do not need the law, or that if you have a law for them, you should also have a DV legislation for us. So far we have been able to handle the backlash, but we don't know what the future awaits. Thank you, everyone, for your patience and for letting me talk for so long. Thank you. I
Oh,
think,
thanks so much,
yes.
Professor. I know that you have other members of your team. I don't know if they, want to make a few comments before we transition to the other presenters.
Would you want to, I don't know, I mean, this is how we had discussed the thing to be, but Agna, would you, or Arushika, would you want to answer Nancy ma'am's question, or do you want me to answer it?
Okay, well, in the interest of time, maybe you could respond to Nancy and then we'll move
Yes.
on to
No, I'm
Suman.
not trying to say that that rape is worse than domestic violence. What I'm saying is that the Indian, for one, what we need to know is that marital rape is not recognized as an offense in India. It's not a crime to rape one's wife, and that's how the rape laws are designed in India. And there are cases in the Supreme Court. There are also writ petitions to change that and to challenge that. But there is domestic violence has of its many forms. One of the forms is called sexual violence, and sexual violence. Um, rape comes in the category of sexual violence. So I'm not saying that domestic violence is less serious than rape. What I'm saying is that the perception of courts is that rape is a more serious offense, and they would go to any extent to solve that as a problem. And what I'm trying to say is that if that is the perception, we need to understand that it begins in the home. It begins by condoning rapes inside homes in domestic relationships. So that needs to change first. So one needs to amend the rape laws and remove the marital rape exception. That's what I was trying to point out.
Great. Thank you so much, Professor. I think that as legal scholars and people whose experiences in the law, what we understand is that the lived experience of people doesn't align really with the legal systems and structures that we've designed to serve them. And I think that that's you've made that point very well. So I do, unless your team has any comments in the next couple of minutes, I wanted to transition to some other speakers that we have. And so
Um,
we'll,
uh,
oh, go ahead. Mhm.
Kumar or Agna or Arishika, do you want to add anything or you want to mention anything?
Thank you so much, ma'am. First of all, thank you to Dr. Lavitu for this huge opportunity. Also, thank you, Suman ma'am, for such a comprehensive commentary on the state of situation with regards to not only domestic violence but intimate partner violence in general in India. I would just like to add one thing, and since it's pertaining to my research, that unlike the United States, the Indian intimate partner violence legal Rubicon actually has an exclusionary ring, which doesn't include any relationship outside marriage. And in 2013, in the landmark judgment, the Supreme Court said that people who are not married, who are living in a relationship, who are living together, may also get the benefit of Domestic Violence Act. Now, from the face of it, it is one of the more progressive judgments, but at the same time, they gave certain criteria as in which kind of relationship qualifies as a domestic relationship. And if we go through all the criteria, which I won't do because of paucity of time, we can see they're talking about a quasi-marital relationship. So with this, I would like to conclude my part. Thank you so much once again. And I would love to listen to the other speakers as well. Thank you, ma'am.
Thank you. Thank you. Arushika, I just wanted to give you an opportunity for a moment. I think she was having some internet problems. So
Yes.
if she'd like to come on later or respond to questions in the chat, that's just fine. I'm going to move on now to some of our other presenters. So thank you so much to our colleagues in India. Certainly, we invite you to remain with us, but we also recognize that it is very, very late for you there. So if there are questions that come up, I'm happy to send them your way if you can't remain on. So the next thing that we're going to do is we're going to take a look at the approaches that have been used in the United States to address domestic violence. Kimberly Wong, who's a clinician working with survivors and others who've experienced trauma, will help us to imagine going beyond trauma informed and considering the ways that we can support survivors of domestic violence through building resiliency. Reena Patel, a licensed clinical social worker, will provide perspective from her work with Indian survivors of domestic violence living in the United States. And then I'll explore the current approaches to addressing domestic violence in the United States, including alternative and forward-thinking approaches. Kimberly, are you ready to begin?
I am. First of all, let me share my screen. Thank you so much from the presenters from India to Dr. Suman, Kumar, and Arushika. It's so good to see you and learned so much about the status of domestic violence in India. I'm I'm honored and excited to participate in this training and in this workshop, and excited to present with you, the folks from India, as well as my colleagues in the United States. My name is Kimberly Wong. I'm a licensed clinical social worker and psychotherapist practicing in the United States in California. I began my career working in sexual and domestic violence survivors over 30 years ago. And in the past 12 years, I've incorporated more of a biological, somatic, or body-based approaches using the community resiliency model, as well as the trauma resiliency models, which are known as CRIM and TRIM. And these models recognize how trauma impacts the body and the automatic survival responses and how to build resilience. The model itself is both trauma and resiliency informed. So in the United States, there's a big prison system, and the conventional perspective is that people are bad and need to be punished. And we look at what's wrong with you. But shifting awareness and becoming trauma informed recognizes that people are suffering and that trauma can have an impact on a person's development, their body and their brain. And so the question is, what happened to you, not what's wrong with you. And shifting further into becoming resiliency informed, we recognize that people are also resilient. They may have been through trauma and they're also resilient, and they can learn skills that can help reduce their suffering. And so we look at, what are your strengths? So CRIM and TRIM are both trauma and resiliency informed. So we have this understanding that people can change and grow. And people can also learn skills and to learn to read their own nervous system to help build resiliency and within themselves and others, as well as empathy. Again, it's about biology, not mental weakness, which is the conventional perspective. We recognize in this that everyone has a nervous system, and that as a result, there are common human reactions to stressful and traumatic events that affect the mind, body, and spirit. And that skills such as CRIM, Community Resiliency Model, and TRIM can help individuals read the nervous system, again, to help increase wellness and resiliency. I'm going to talk broadly about trauma as opposed to the clinical definition of PTSD. We know that domestic violence has profound and far-reaching effects. So we heard a lot of things from Dr. Suman about the legal system. We know that it affects individuals as well as the systems. She referenced the legal system, the hospital systems, financial, and familial. So in terms of an individual survivor, these are the areas in which that common reactions after a traumatic event. Survivors often have fear and anxiety, anger, depression, and shame. Physically, there may be some problems with sleep, appetite, the part of the nervous system, the autonomic nervous system can kick in, increasing heart rate, breath, digestion. And this is important in terms of survival responses that happen. Survivors often have negative thoughts, may have dissociation, forgetfulness, nightmares. And then this often leads people to addiction or self-injury, anger outbursts, isolation. And of course, this can impact relationships. People can lose hope or have changes in faith. From a resiliency perspective, many survivors end up becoming advocates. They they recognize their own strength and courage, create hope and compassion for themselves and others, as well as new meanings. Now, trauma can be defined as trauma and toxic shock can be defined as shock trauma, which is some things that happen too much too fast and that can overwhelm the nervous system. And it can include things like gender-based violence, sexual assault, abuse, natural disasters. Developmental traumas are things that happen ongoing. So there can be too little for too long. So such as neglect and poverty, racism. And there can also be shock and developmental combined, which is can be like too much for too long. And this is where like ongoing domestic violence, child abuse, child sexual abuse can occur. And within both developmental traumas, they can end up being intergenerational as well as historical, meaning traumas against communities. There's a concept of going to resiliency, a concept of the resilience zone. And within the resilience zone, the three different parts of our brain are working fluidly together and are accessible. Our survival, our thinking, our emotional brains are all connected. And in this resilience zone, we feel like we can manage life's problems. We can problem solve, we can think clearly, and we can also have a range of emotions within this. So it's an okay zone. You can feel happy and you can also feel sad, anxious, angry, depressed. But as long as you can function and think clearly, you're in that resilience zone. You can manage your life. And the thing that can happen is with a traumatic or stressful event, it can disrupt this and bump someone out of the resilience zone. So that in some ways, a lot of times when people are bumped out of that resilience zone, those three parts of the brain are no longer working fluidly together. And a lot of times it's almost like your thinking brain goes offline. And so it's not as accessible. So this is why people in crisis may have difficulty problem solving. And so the person is no longer able to manage life's problems. And so you go from mild anxiety and getting bumped out to overwhelmed panic where you can't think clearly, or anger outbursts. And then getting energy going down is more depression. And depression in the sense of there's isolation, your thoughts might be foggy or slow, numbness or disconnection. I mentioned the three parts. I'm going very quickly, but I mentioned the three parts of the brain. And I'm going to talk first about and this is a simplistic model, the survival brain. And the survival brain is the first part of the brain that kicks in, that is formed. And it is part of that brain step. And its primary function is to keep us alive. These are the things that your body does without you having to think about it. It is unconscious and instinctual. And what happens here is that it is responsible for things like digestion, reproduction, circulation, and breath. And so those are all part of that autonomic nervous system, of the part of the nervous system that does things without us having to think about, and it regulates those things like heart rate. It keeps us alive. So the other thing is it carries out the survival responses of fight, flight, and freeze. And so moving on into the emotional network, it is responsible for emotions, feelings, attachment. And a primary function is also risk assessment. It's constantly looking for threats. And this is, again, not necessarily from the thinking brain. And if it identifies it's something that appears to be a threat, it will sound an alarm to initiate survival responses and to initiate that survival network. The last part of our brain to form is our cortex, or our thinking network. And this is what's associated with our speech, language, thoughts, judgment, and planning. And again, remembering that if somebody gets kind of bumped out or experiencing trauma, sometimes that thinking brain is not entirely as accessible. I'm going to talk very briefly about survival responses. And there are 4 different ones that I'm going to mention. most people have probably heard of fight and flight. Possibly you've heard of freeze. And then there's also this survival response of tend and befriend. And from a biological perspective, we recognize that survival responses are biological. They are protective. They're about keeping you alive. And if there is any perception that to threat and safety, that these responses, one of these responses might engage. Now, the thing is, they often become automatic, and they are guided by the survival brain, not the thinking brain. And templates can be formed. And so from a biological perspective, fight and flight is a response that, when I mentioned earlier about the autonomic nervous system, which regulates heart rate, if there's an introduction of some sort of threat, various things like stress hormones are released, like adrenaline or cortisol, that initiate the autonomic nervous system to increase heart rate, breath, because ultimately what it's doing is it's mobilizing your large muscle groups, arms and legs, so you can fight or flee. Now, freeze comes in when fighting and fleeing, a situation may feel inescapable. And this, you might think about, like, a lot of times when people have experienced abuse as a child, where they're harmed by individuals who are larger or stronger, fight and flee is not necessarily possible. So freeze is often maybe a response that someone has. And because templates are formed, if something has worked to help someone survive in the past, it might become their go-to response. And so we do find people sometimes freezing in cases when escape could be possible, but that's the automatic survival brain response, survival response to freeze. Now, tend and befriend. My colleague in Reena Patel who will be speaking right after me, is going to talk a little bit more in depth about this. And just briefly, tend and befriend engages, rather than cortisol and adrenaline, oxytocin is released into the system, which promotes social behaviors. And this idea of tend and befriend, because not everybody fights, flees, or freezes. So sometimes people tend to offspring, to children. They make sure other people are okay. That would be tending. They might be seeking out social groups for a mutual defense. And befriending so that's where befriending comes in. And why it becomes also very relevant is that befriending comes in because people might befriend the person who's harming you. And so you can see how relevant this is with domestic violence. So I'm going to end with what we also know about the brain is that the things that we focus on in the brain, or things that we focus on or pay attention to, are the things that we can grow. And this is connected to this idea of neuroplasticity, which it means ultimately that your brain can continue to change and grow based on various experiences. And so part of this biological or somatic model is paying attention to sensations in your body. And when you can start to notice sensations, distinguish between sensations of distress and wellness, you have a choice on what you pay attention to. I'm going to talk very briefly about the community resiliency model skills, and there are 6 skills. I've listed 4 of the 6, and I will provide you with information about how to access more. But these resiliency skills are based on a foundational one is tracking, which is paying attention to the sensations in your body. Again, learning to distinguish between pleasant, unpleasant, and neutral. And there are also wellness skills such as resourcing and grounding, which can help build wellness within the body and grow that within your brain. And so a resource is essentially something that provides comfort, peace, or joy, and then connecting to the wellness sensations that go along with that. And then grounding is about have gravitational security and having a sense of security with your connection to the earth, which also helps people build resilience. Now, the help now, reset now skills, I mentioned that resilience zone when somebody gets bumped out, remembering that a thinking brain is not as accessible, that what it does is it helps focus on helps engage the brain by focusing on oftentimes external senses like sight, sound, smell, and taste. And what this helps people to do is to get back into the present moment and to help them get back into that resilience zone. And also part of trauma-informed therapy, which I'm not talking necessarily about, but trauma processing has to do with paying attention to sensations, because we know that when survival responses are initiated, the thinking brain's not as online. So part of working with people to process some of the trauma is working with the sensations in the body, keeping in mind that the survival brain's not responding to language, but it responds to sensations. So this next slide here is where you can get information more specifically about the community resiliency model, which anybody can use, and it's free. You can download it on download it onto your phone, as well as the iChill app. .com onto a website, and it talks about the different skills and that is available to you. And so lastly, I am going to end with I am going to introduce my colleague, Reena Patel, my friend and colleague that I have known. I was thinking about it. I think I've known her for about 10 years. And she and I met each other through the Trauma Resource Institute in working with the trauma resiliency model. She and I also worked in the Equity, Diversity, and Inclusion Committee of the Trauma Resource Institute for several years. And also remember that she and I participated on a podcast to talk about diverse experiences of Asian Americans. She will be talking about domestic violence and the Indian immigrant community, Indian immigrants in the United States. And she has a special perspective because she studied as well as worked in India as well and in the United States. And so I'm so happy to be able to pass this on to her, and I will stop sharing.
Thank you so much, Kimberly. Thank you. Thank you. I am so honored to be here and so grateful. I'm going to do my best to share some thoughts and reflections and some data with all of you. I also want to say thank you to the team from India, Dr. Suman, that your presentation was incredible and just really helpful. And I will just go ahead and dive in. I'm going to share my screen. And Kimberly really supported in helping. I'll refer to Kimberly's presentation as well. As she mentioned, I am also have also worked with the Trauma Resource Institute and also teach some of those skills to survivors of gender-based violence. I've noticed that a lot of South Asian community, Indian community respond really well to this model because it is working with our biology and our sensations. And so it really works across culture. Just touch on this briefly. This is a forum about how are we creating more justice around these experiences. And I just want to say by sharing some of these things, what I'm hoping to do is that we're moving from inequality, equality, right? Equity, giving folks the same amount of resources. And I would say with the Indian immigrant community here in the United States, yes, they have access to the same laws, to the same resources. But what does justice look like? What does it really look like for these folks to find the help and support that they need? And what I want to emphasize here is that there is not a lot of information or research, right, around what the experience is. And as our colleagues in India have mentioned, there are some very deep-rooted power structures, mindsets and experiences in our culture and our community that it doesn't go away when people come to the United States. In fact, what it sets up is situations for people to be more vulnerable and isolated because now you're in a foreign country and you're having to navigate laws and systems that are unfamiliar to you. So one of the things I want to mention here as we talk about this is intersectionality. And I'll just touch on this briefly, that when we are talking about the Indian immigrant community in the United States, it is so important that when we're assessing and understanding this, that we're looking at these factors, right? Education, class mobility, language diversity, right? Immigration status, documentation status, what kind of visa does someone have? That really does make a difference. Someone with an H-1B visa may not have access to economic employment. They have to go through their husband or their partner. And caste, right? As even in the United States, this is still a factor in terms of accessing resources, power hierarchy, even within the Indian community here. It is so diverse. Even for myself growing up here, there were certain groups I was allowed to communicate with, and I was not, even growing up in the United States within the Indian community. So just wanting to emphasize that piece. The model minority myth and the implications on mental health, and I'll add here, on people seeking help and resources, right? When we think about the Asian American Pacific Islander community, the Indian community, there is very much an expectation for folks to perform a certain way. And I would say the model minority myth, coined by William Peterson in 1966, has continued to do a lot of damage around a lot of South Asians, a lot of Indian immigrants seeking help. It's typically like, hey, there's nothing to see here about what's going on, right? That we're just minding our business and we're doing what we need to. We're not here to cause trouble, right? And so the model minority myth came from that. How are we different from other communities that were protesting and advocating for themselves, like the Black community, the Hispanic community in the 1960s and 70s? And so what this has done essentially is it's contributed to folks not being able to speak up, in the ways that domestic violence manifests in the Indian immigrant community here. Oftentimes, as I was listening to our colleagues in India, it's interesting because oftentimes here, it is very private. There aren't very many public signs of what is happening. There's more financial exploitation, emotional abuse, verbal abuse that can happen behind closed doors. And this goes across class, right? So the folks that I work with in my practice as a social worker, I work with physicians, I work with people in the tech industry, computer science, folks, software engineers, and even in earning high incomes does not provide immunity to what is happening behind closed doors. And even this idea of consent and self-worth and the things that are carried over in these situations, and then thinking about asking for help and what that would look like and what that would mean. So when we start thinking about the bias that we might have of the model minority community, and in fact, I'm doing research for this presentation, I actually found an article that was written last year that said, Asian Americans are the least likely to experience intimate partner violence. And I was shocked. And that is because it is so underreported. And I will share before the end of the presentation some of the stats around this from organizations working directly with South Asian survivors. But that statement in and of itself is very illuminating. To think that Asian American people are the least likely to experience domestic violence in the United States, that is a problem of reporting, that is a problem of being seen and understood. And when in fact we know that Indian immigrant community actually does have a very high rate of gender-based violence and domestic violence. And so this bias can turn into prejudice. Even for those of us that are well-meaning, we may not screen or understand or even go to look for these signs or ask the extra questions when somebody comes to an emergency room. There's discrimination that starts to happen right through our actions. And then subsequently racism, right? The power structures will start to evolve so that folks do not have access to these services and for help. And so I will move forward. I know this is a lot here, the considerations working with the Indian immigrant community, but some things I really want to highlight. I had spoken about my family earlier. And when we think about how things are set up for the Indian immigrant community, and again, I'll speak specifically about my experience as a Gujarati American, when my grandmother came and even all of her daughters, right, they were working in a motel, right? And that's a pretty common stereotype, right? But a lot of South Asian, a lot of Indian immigrants, they have businesses, they have motels or hotels or gas stations. And what ends up happening is women are not on the payroll. So there's no Social Security, there's no unemployment. And so if someone wants to leave a marriage or a situation, it becomes very difficult. There's no transparency with the finances. And in fact, I've seen many relatives, many community members who've worked their whole lives in a motel or a gas station. And if they do want to leave, they have nothing to show for the work that they've done, which now sets up a situation of economic disempowerment and scarcity and poverty for these folks. And so this is really important to remember when we're thinking about working with the Indian immigrant community. Now, this is not everyone's situation. Each one is unique. These are just some things to think about, the nuances. Lack of familiarity with systems and resources like the Violence Against Women Act. Do they have support within the United States or in India with their family back home? Was this a love marriage or an arranged marriage? That does make a difference if people feel like they can actually ask for help or not, right? A lack of culturally affirming providers, assimilation, where you are generationally as well. What I am noticing in my own practice is that it's a very interesting trend anecdotally that second and third generation Indian immigrant women are now starting to confront their own mothers and grandmothers around the domestic violence in their homes. These newer generations that are trying to break cycles are now bringing forth that this is not okay and starting to disrupt the fabric of what is happening, which also in itself has a lot of mental health and social implications. A lot of Indian immigrant women are quite isolated. The communities tend to be more insular, right? And again, so that means that who are you going to ask for help, right? Can people understand what you're going through? There's a diversity of religion as well and ethnicity. Access to education, right? Without a green card or the appropriate documentation, are people being able to access education as well? And this desire for upward mobility. And I'm going to talk about this with the survival response just briefly, but making sure that their children have everything they need to be successful can often be a driving force in staying also in a situation that is potentially violent or harmful, because there is such a desire for upward mobility. And as we know, that comes from an immigrant experience of wanting, from colonization and poverty and wanting to see a better future for their children as well. So that is definitely coming into play when I work with a lot of these folks. Kimberly went over this beautifully. The survival responses, they are automatic. And what I would like to say specifically about the Indian immigrant community and how this manifests, I do not want to make overgeneralizations. And so please take this and do your own research around this and just how this sits with all of you. But what I'm noticing more and more is this tend and befriend response that Kimberly talked about, right? And also what happens when we orient safety over time to what's happening outside of us, right? That when our safety is connected to if the other people in our life are okay, which absolutely for an Indian immigrant woman, this is something that happens. This is a biological response and a very proactive and adaptive response. However, when this response continues to keep happening and it's stuck, and as Kimberly talked about, the templates are formed, right? What starts to happen is that we start to abandon sense of self, right, in order to make sure others are okay. And I also see this manifesting when folks are going to work for different institutions, right? Also in their family system, taking care of their in-laws, right? There's so many ways in which this manifests in the community, because I think the power structures are ripe for this to be something that can occur when we're in a collective community, when our survival ancestrally, when we think about Indian women or Indian folks in general, because they're absolutely all genders experience this, is that our survival is based on the community and being able to be a part of the village and community so our children are safe. Again, those things don't just go away. Now we're here in the United States and we're also grappling with this. And now it's starting to look like, okay, we're befriending the perpetrator or the people around us that are causing us harm, because that is how we know our sense of safety. A lot of the work I do with Indian immigrant women is about finding consent again, and finding those sensations connected to their own power and consent around saying yes or no to relationships, to boundaries within themselves, to start to figure out what they would like to do next, right? But there's a lot of unlearning and recognizing how these survival responses have kept people safe for so long. Even though outwardly it may not look like it, it has kept folks safe within family and community for so long. Intergenerational trauma, and I know I have just like a minute left. So intergenerational trauma, I just want to also mention that this is something else I see with the Indian immigrant community, that these things are passed down through our epigenetics, psychologically, behaviorally, environmentally, that if our ancestors were carrying an extreme amount of stress, right, that does affect our gene expression, and we are more likely to develop long-term symptoms of trauma. Some of the data on Indian immigrants and domestic violence, that Indians do make up the largest foreign-born population in the United States. That's as of 2022, about 4.8 million. And this is something I just want to highlight, that out of, there was a study done in 2022 as well, 468 South Asian men and women across 50 states. The types of violence is what I want to highlight, is that 48% reported physical violence, 38 emotional, 35% economic, 26% immigration related, 27% verbal, 19% in-law related, and 11% sexual abuse. So, even as we're hearing the different types of violence that are occurring, right, this is again another indicator of how we can work with this community. And I encourage anyone who's interested in more information to read this report. Together We Rise is a one-of-a-kind report. Hopefully there'll be many more published from an organization called South Asian SOAR, which really took 30 plus frontline organizations working with South Asians and gender-based violence, allies, survivors, a coalition, to really understand what's happening. And what they found, right, was that over 48% of South Asians in the United States experience some sort of gender-based violence. That's about half, right? And so this is what I'm talking about when I say that there's still so much to learn. There's only been, very few studies in the last 10 years of the experience of Indian immigrant women with gender-based violence. So there is definitely a gap here of understanding these experiences more. And 58% of South Asian survivors are not US citizens. 49% are unemployed or underemployed. So the piece I was talking about with the economic development and workforce development around this community is so important to regain legal and economic power. And I'll leave you all with this quote, something to think about, that trauma in a person decontextualized over time looks like personality. Trauma in a family decontextualized over time looks like family traits. And trauma in a people decontextualized over time can look like culture. And that is from Resma Manikam. And so I just wanted to mention that if anyone's interested in his work. And thank you so much for your time. And yes, thank you so much.
Thank you so much, Rena. I so appreciate the context that you and Kimberly provide in really grounding us to the lived experiences of domestic violence survivors. My job at this point is now to give us an overview of the legal and policy mechanisms, and sometimes those can become disembodied from the real lived experience. And I think that Professor Suman sort of alluded to that when she was talking about cases, the way that the real lived experiences of women survivors don't really translate a lot of times into how we develop policy. And so my job now is to very quickly do an overview of what some of those systems look like here in the United States. I do want to recognize and acknowledge that as I get my slides up here, recognize and acknowledge that we still have one more section after I do my few minutes, and that is maybe even the most important section, how we connect this to human rights, the work of our future student scholars and their recommendations. So even if we go over a little bit, I invite you and encourage you to stay on the line on the workshop if you're able to. So I'm going to try to very briefly give us a bird's eye overview of what the patchwork of domestic violence law and policy looks like in the American context. And when I say bird's eye, I do mean bird's eye. This is certainly not exhaustive or comprehensive. It's just a brief overview. Just as a caveat as we begin, things are changing very quickly. What I'm sharing is what we have known and practiced up until 2025 when the second Trump administration took office. But we know that a lot of these legal structures are changing, especially at the federal level. So I just wanted to, sort of start us there. We can't really talk about law and policy in the United States without recognizing federalism. This is a sort of unique way of applying law. It doesn't apply in every country. As a matter of fact, in India, right, they use a national approach. So policy is developed nationally. Whereas in the United States, the federalism essentially is a division and sharing of power between national and state governments. So the federal government reserves for itself certain powers to regulate things like interstate commerce and immigration and foreign policy. But almost everything else is really left up to the states. So I am going to review some of the federal policy. It primarily has to do with how states receive funding to do domestic violence work in their state, but also some immigration policy. And we heard some references, especially from Rena, about some of these. So perhaps the most overarching federal policy that we use to address domestic violence in the United States is the Violence Against Women Act of 1994. So this was the first federal systemic response to gender-based violence. Many advocates say it was the attempt to operationalize, the U.S. ascension to the Declaration on the Elimination of Violence Against Women. And some of our students will talk about that within the context of their presentations. Within the Violence Against Women Act, there are several core mechanisms. Both criminal and civil legal remedies and responses are built in. Funding specifically for victim services. It hadn't existed before this time. For both victim services that are occurring within the criminal legal system and outside of the criminal legal system. Additionally, the Violence Against Women Act, put an emphasis on the importance of addressing the needs of populations of domestic violence survivors that are particularly vulnerable. So, thinking of some of what Rena was talking about in terms of immigration and the impact. So within the Violence Against Women Act, there are protections for undocumented survivors, for jurisdictional issues related to Indigenous and Native American survivors. And then because it's a federal funding bill, it is reauthorized or reviewed every few years. And so other types of provisions have been added, things like educational protections, housing protections, and confidentiality. So to think again about the vulnerability of immigrant or undocumented survivors of domestic violence, I want to talk a bit more about some of the protections that are available within the context of immigration. So most immigration protections for domestic violence survivors are governed by federal law because of federalism. But states have played an increasingly critical role in ensuring that survivors have access to benefits and legal representation and even protection from enforcement. So probably the most common tool that is used for undocumented survivors to protect them is what we call a self-petition in the Violence Against Women Act. And self-petition makes reference to the fact that much of our immigration policy is built around family-based immigration. And for survivors who are immigrant and undocumented, this could translate into an abuse tool for abusers. And so the Violence Against Women Act allows survivors to do something called a self-petition so that they don't have to tell the abuser about trying to apply for status. Now, I am very much aware of what's happening in terms of immigration policy in this country. As a matter of fact, in 2026, we've seen the USCIS, which is the entity that these are submitted to, has increased the scrutiny of these types of petitions. In fact, they've focused their attention on what a good faith marriage is, emphasize shared residence requirements. All of these things can be difficult and challenging for undocumented survivors. And another tool at the federal level that's available for undocumented survivors of domestic violence is a victim of crime visa, or a U visa. So victims of qualifying crimes, including domestic violence, can apply for these temporary visas that can translate into longer term stays. But the reality is that these require a level of cooperation with law enforcement and prosecutors that may not be conducive to the experiences of domestic survivors for a variety of reasons, domestic violence survivors for a variety of reasons. As I mentioned before, the states have played an increasing role in addressing the needs of domestic violence survivors, including states like California, New York, and Illinois, the so-called sanctuary states that have limited local police cooperation with immigration and customs enforcement. States like Washington and New Jersey, who have prohibited immigration and arrest inside and near state courthouses, not federal courthouses. They don't have jurisdiction there. And even some states, like in California, if a survivor has a U visa pending through the federal government or in this through prosecutors in the state, then they can access benefits like housing support, food support, and cash aid. But as I noted before, a vast majority of domestic violence law and protections exist in state law because the federal government only regulates a few things. So this includes the criminal codes that we use to define domestic violence for prosecution and how criminal justice response should occur, as well as civil protections in family, labor, housing, health, and education code. So, for example, in states like California, the definition of domestic violence for prosecution is actually quite expansive. I believe that Kumar mentioned this in relationship to India, that there is no way to include somebody who doesn't have a marriage relationship. Well, in California, right, the domestic violence code includes people who somebody dates, a live-in romantic partner, or someone that they've previously dated. While in Texas, the definition of domestic violence is more restrictive. States also develop tools to ensure that their response by criminal justice responders are consistent. So, for example, in the state, they might determine mandatory arrests for domestic violence. They might require assessments for who the actual abuser is, and they might require the presence of a victim advocate. In terms of civil protections, right, this is usually in the form of a domestic violence protection order, which is typically granted through family courts. But work entities and schools can also apply for domestic violence protection orders in some states to protect victims who work or go to school in their institution. California and other states like Hawaii provide certain leave or time off for domestic violence victims to go to court. There are housing protections built into some state statutes that protect against eviction. And most states actually have some required mandatory training in domestic violence for healthcare providers. An issue that I did want to raise that will be touched on later by some of the students, that is really a gap in how we develop domestic violence law in the US, is the reality of the criminalization of resistive violence. So data on resistive violence indicates that women report using violence against their partners as a form of self-defense or resistance. Upwards of 94% of some women prison populations have histories of physical and sexual abuse before incarceration. And we heard Professor Suman allude to this in her presentation. Similarly, here in the US, women are disproportionately incarcerated for domestic violence cases compared to their male counterparts, often receiving sentences that are actually much harsher. And one of the reasons for this is because there's really no overarching defense to resistive violence. The typical defenses that one might raise in these kinds of situations would be self-defense, but there's a reasonableness standard that we can't really articulate fully if we're not able to fully account for the survivor's experiences, which isn't always possible in a courtroom. So some states have implemented statutes, like in California, we call it battering and its effects, which allows for certain types of evidence to be admitted by the defense that would support the jury or the judge's understanding of the context in which a domestic violence victim might fight back against her abuser. So it's challenging, right, to introduce this kind of evidence. Usually it requires a pretty substantial presentation of a consistent history of violence. And oftentimes juries are very skeptical of this type of a defense. But states like New York have introduced these defenses successfully. I want to quickly touch on a couple of other alternatives that have been used before I close by thinking about sort of domestic violence outside of the criminal justice system. So restorative justice is a type of alternative to the existing system that focuses on the survivor's needs. Some research has shown that when partnered with the criminal justice system response, that it can reduce recidivism and increase victim safety. But for many survivors, the criminal justice system just isn't really an option. And of course, it relies on the survivor's ability to be able to engage in these practices without fear, which is not usually the case in domestic violence. And so that means that we might want to consider other alternatives, including what advocates call transformative justice, which operates outside of the criminal legal system to address the root causes of violence like poverty and inequality. And ultimately, advocates for this type of justice suggest that transformative justice can create and cultivate the very things known to help prevent violence like resilience, safety, healing, and connection. And to close, I just want to identify some of the ways that maybe we are embodying that transformative justice approach in law. One is by increasingly viewing domestic violence as a public health issue. So in 2010, the Affordable Care Act, which is federal policy, recognized domestic violence had a negative impact on victims' health. And the Family Violence Prevention Services Act, which is a counterpart to the Violence Against Women Act, actually provides grants to programs that are serving domestic violence victims that focus on improving conditions in communities, schools, workplaces, and neighborhoods, and create a climate that promotes positive norms. And then also to think about the way that our public policy views domestic violence as an economic issue. States are increasingly including right to housing, Social Security and cash aid for domestic violence victims, and paid safe leave laws. So I'm sorry, I know that that was a very quick overview, but I did want to make sure that we are able to transition now to looking at domestic violence within the context of the human rights framework. So while I think Professor Suman articulated this very well at the beginning, that historically we've looked at domestic violence as a private issue, an action on from one person on another. But human rights defenders and gender-based violence advocates have always recognized that the only way to ensure access to justice and full participation in public life for women was by connecting those private actions and to public obligations and linking gender-based violence to historically unequal power dynamics within society. So this framework is what student scholars from the California State University Northridge's Criminology and Justice Studies Department have been exploring, and will share their work with you and their recommendations, most specifically focused on access to justice for domestic violence, especially for survivors in vulnerable groups. So the first group is going to speak to criminal justice responses. Angelina, are you prepared to start us off?
Yes, I am. Thank you, Professor Labertu.
You're welcome.
Good morning, everyone. Thank you for having me today. My name is Angelina Sandoval, and I am currently a criminology student at California State University, Northridge. It is truly an honor to open up this discussion and introduce my group's research on the topic of how our criminal justice system responds to domestic violence. Domestic violence is often talked about as a private issue, but through our research, we have seen that it is deeply connected to how our legal systems function that can create public harm. The institutions should be responsible for, especially when it comes to women's safety and their access to justice. While the United States does have laws in place, such as the Violence Against Women Act, our findings show that having laws on paper does not always guarantee consistent protection in practice. Despite legal frameworks, Despite legal frameworks in place, the United States ranks 115 out of 142 countries in access to justice. This highlights larger structural barriers that can limit meaningful legal protection for women. In our presentation, we will focus on five main areas: policing, prosecuting, child support, victim support, and access to justice overall. We will begin by discussing policing responses and how the police can better respond to victims when it comes to concern of lack of training, trust, and the need for more victim-centered approaches. We will then look at prosecution and how decisions are made about moving cases forward within the criminal justice system. Next, we will address child support and how survivors seeking financial stability can face complicated legal procedures that may unintentionally increase their vulnerability. We will also examine victim support services, including things like access to shelters, legal advocacy, and long-term assistance, and how funding gaps and inconsistent enforcement can affect survivor safety. Finally, we will discuss access to justice more broadly. For each topic, we will briefly outline the relevant domestic and international framework, including the Convention on the Elimination of Discrimination Against Women. We will also examine issues of compliance and then conclude with recommendations for strengthening survivor center and equitable responses. These recommendations focus on improving coordination, extending protections, ensuring that the legal standards translate into real safety that can also have institution accountability. With this introduction, I would now like to invite my classmates to speak more in depth on our topic. Thank you for having me here today.
Hello, my name is Sergio Lopez, and I am a graduating senior. Thank you for your attention for joining the conference. Currently, the United States ranks 115th out of 142 countries in access to justice. While we have robust-looking laws, there's a profound disconnect between legal theory and survivor reality. Our current legal framework, specifically the Violence Against Women Act and international treaties, are being undermined by inconsistent enforcement, leaving nearly 60% of survivors without the help they need. The Violence Against Women Act is our primary tool. It focuses heavily on the prosecution pillar and funds shelters and mandates that protection orders be honored across state lines. However, its heavy reliance on criminal justice funding often makes it less accessible to immigrant survivors, those in marginalized social statuses. Under the UN Declaration on the Elimination Against Women Act, the U.S. obligates to eliminate violence without delay. This is a human rights framework, viewing safety as a fundamental right rather than privilege granted by a successful prosecution. Article 13b also allows courts to refuse to return a child to a country if there is a grave risk of harm. Yet in U.S. practice, the burden of proof falls entirely on the survivor, creating immense financial and emotional hurdles that often prioritize international community over individual safety. The Committee Against Torture is our most powerful accountability tool. Under General Comment Number 2, the Committee Against Torture explicitly includes gender-based violence, such as domestic violence, within its scope. It establishes that when a state fails to exercise due diligence to prevent or punish private violence, it is complicit in cruel, inhumane, or degrading treatment. Under the Convention Against Torture, domestic violence is no longer just a private matter. If the state fails to protect the known victim, that failure constitutes a state-sanctioned violation of human rights. Despite these laws, the U.S. is only moderately compliant due to three critical gaps: policing failures, and that many officers lack trauma-informed training, as seen in the city of Torrington v. Thurman. Police inaction can be a violation of equal protection rights. Current prosecution rates remain low because the system relies on perfect victims rather than understanding the nuances of trauma. Economic mobilization, in which child support system is often exploited by abusers. Mandatory court hearings and documentation requirements allow perpetrators to locate or financially sabotage survivors who are simply trying to gain independence. And lastly, judicial blind spots, where we see family courts frequently prioritize parental rights over documented histories of abuse, unintentionally placing children back into dangerous environments. True victim support must include economic firewalls that protect the survivor's location and financial independence. The solution is that we must move beyond just having laws to meaningful compliance. This requires expanding legal definitions to include coercive control and financial abuse, mandating trauma-informed policing nationwide, and implementing confidentiality protections in child support enforcement. Legal frameworks alone do not suffice. Safety only exists when the law is as accessible as it is written. We must shift our perspective from viewing domestic violence as a private criminal matter and start treating it as a state responsibility. When we fail to protect survivors, we aren't just failing our citizens, we are violating international law. Thank you.
Hi everyone, my name is Reagan Jackson. Together as a team, we came up with recommendations that encourage and are based around a victim-centered and trauma-informed approach that creates an environment for survivors to have immediate protection along with long-term safety and stability. For survivors, there are many different experiences, often layered and very complex. It is imperative that our systems must respond in ways that acknowledge the harm without sacrificing survivor autonomy or shifting responsibility away from those who commit crimes. It's significant for policies and procedures to be carefully designed and reinforced in ways that avoid re-traumatization and to confront the systemic inequalities that disproportionately impact marginalized communities. A comprehensive response must reinforce clear core values such as domestic violence is a serious crime, that survivors and their safety are the top priority, and that accountability and compassion can and will be able to coexist. The principles that we have and will highlight are the Association of Chiefs of Police that essentially emphasize ethical leadership, evidence-based practice, and victim support. Specifically, policing responses to domestic violence should also strengthen mandatory trauma-informed, victim-centered training. Research confirms that a victim-centered approach allows for the survivor to benefit but also improves case processing and outcomes. Ultimately, establishing an understanding that shifting the focus to the victim is not weakness in enforcement, rather it is a reform grounded it is a reform grounded in evidence and effectiveness. Beyond initial response, our court processes must be redesigned with safety in mind as well. This can include providing separate waiting areas and staggered court times to prevent contact between parties, allowing states to process child support payments that ensure confidentiality protections that reduces the risk of retaliation among the parties. As researchers of our issue, we have a responsibility to support policies that acknowledge and bring awareness to real-world impact of domestic violence on the communities. Through advocating for trauma-informed systems, equitable practices, survivor-centered standards, we contribute to a broader culture of safety and accountability. In conclusion, a criminal justice response to domestic violence isn't only about enforcement as it entails dignity, safety, and sustainable change. If we commit to centering victims within holding offenders accountable, we create a system that truly protects those it is meant to serve and protect. Addressing criminal justice responses to domestic violence requires more than procedural reform. Rather, it requires an entire cultural shift. Thank you for your time.
Thank you, Angelina, Sergio, and Reagan. Now we're going to our second group who spent time researching the criminalization of self-defense through a human rights lens. Madeline, are you ready?
Yes. Can you hear me and see me?
We can.
Alrighty. I just want to start off by saying thank you. Hello, my name is Madeline Burton, and I am presenting on behalf of my peers at CSUN on the criminalization of self-defense. Self-defense is the legal use of reasonable and necessary force. However, the scope of reasonableness is often narrowly applied and is typically viewed through the lens of masculinity, as only 27% of lawmakers around the world identify as female. We can see how a lack of women in office contributes to the myopic, one-size-fits-all approach to gender-based violence, because in countries like Rwanda, women hold over 60% of parliamentary seats and have become number one on the Inter-Parliamentary Union's list tracking gender equality. The criminalization of self-defense is centered around disproportionate in sentencing and punitive measures in place set to uphold racial and gender-based discrepancies in our criminal justice system. Historically, women have been excluded from discussions in legal proceedings on human rights and discrimination until the Convention on the Elimination of All Forms of Discrimination Against Women, more commonly known as CEDAW, which has been in effect since 1981, which established a framework for what constitutes discrimination against women and set out state and government obligations. The United States is among 6 countries that have yet to ratify this convention. For a country built on the premise of liberty and justice for all, we are excluding multiple identities from the term all. Although the United States rightfully condemns the atrocities committed against women in Iran by the Islamic Republic, our failure to ratify this convention, along with Iran and countries such as Sudan, Palau, Somalia, and Tonga, paints an incriminating picture about where we stand in global gender equality. The overlap between gender-based violence and the criminalization of self-defense disregards the space for nuance and frames acts of self-defense as arbitrary acts of aggression, battery, and sometimes first-degree murder. Domestic laws in the United States follow the common law principle of the Castle Doctrine. Under this doctrine, individuals have the right to reasonable force, including deadly, without the duty to retreat if the threat is imminent and could result in serious bodily harm or death. However, in cases of domestic violence, many courts deny the Castle Doctrine defense due to the abuser being a cohabitant. Stand your ground laws refer to situations outside of the home and establish an affirmative defense for individuals attempting or threatening to use lethal or non-lethal force if they believe it is necessary to prevent imminent death or great bodily harm. The duty to retreat is eliminated if the individual has not engaged in any form of unlawful activity and has the right to be in the vicinity. Victims are often misidentified as the initial aggressor because the legal system views these cases as one isolated incident rather than a cycle of abuse. Once one is labeled the initial aggressor, the survivor loses the presumption of reasonableness, no matter the amount of documentation. These laws hold the victims to a higher standard and disproportionately target them, specifically women of color. Centoya Brown, who was only 16 years old at the time of her conviction, was sentenced to life in prison and served 15 years after killing the 43-year-old man whom she believed to be reaching for a gun. The 43-year-old man who solicited her for sex. The court decided that he was not actively threatening her life and it did not meet the legal standard of imminence. The state's failure to protect victims infringes upon their right to life by failing to provide equal protection, a fundamental violation of Article 26 of the ICCPR, which explicitly states all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. Human rights should be applied unconditionally. However, the lack of urgency from our nation to implement standards that acknowledge how gender-based violence contributes to the criminalization of survivors demonstrates a fundamental act of dehumanization. Thank you.
Hello, my name is Kiara Barrias. I am also a student at California State University, Northridge. To add on to what my co-presenter Madeline stated earlier, self-defense demands that threats are immediate and that the use of force is not excessive to the threat and that there was no reasonable alternative. There are 35 states in the United States that have stand your ground laws. These laws do not specifically obligate a duty to retreat, do not reinforce lawful actions for defense, and do not require reasonable belief. Alabama, Florida, and Ohio, among others, have these laws. Conversely, international compliance focusing on the criminalization of self-defense using a human rights framework balances proportionality and armed conflict. Article 6 of the International Covenant on Civil and Political Rights contains the right to life, which legalizes but limits the rights of self-defense. Similar to the United States, international law, such as Article 51 of the UN Charter and customary international law, require that the defense be necessary and proportionate to the threat. Furthermore, Article 51 of the UN Charter states that nations have the right to self-defense, but it is restricted to situations involving an armed attack. While Article 51 applies to nations, this concept translates to stand your ground laws and necessity of defenses in domestic criminal law. We need to develop a legal policy like this that is applicable to individuals to protect their human rights and the right to life, especially when their lives are in jeopardy. The policy would legally protect individuals responding to attacks by other individuals or groups. Furthermore, battered woman syndrome is widely recognized in the United States as a legal framework, but it is commonly misunderstood. It is used to support self-defense claims for women who kill their abusers. Over 3/4 of the United States have found expert testimony on battered women syndrome, which is admissible to explain the defendant's state of mind. Conversely, it is not a standalone defense. We are currently shifting from the syndrome to its effects. We are using it for prosecution. This approach conflicts with statutory standards and constitutes ineffective assistance of counsel. Today's compliance based on battered women syndrome in the justice system is aimed at bridging the gap between traditional male-centric self-defense laws and the realities of domestic violence to contextualize an imperfect defense. Complexities of compliance in the laws of the United States and internationally include subjective over objective beliefs and the initial aggressor rule. Courts evaluate whether or not the reasonable person would have acted the same way, and states that the person who initiates the conflict cannot claim self-defense. These rules penalize those who initiated a minor altercation despite facing disproportionate lethal force. This disregards what the actor believed and what a reasonable person would believe is considered self-defense, causing inconsistent legal outcomes and risk of punishing genuine fear. The United States debates these rules as self-defense claims, and international locations debate the equal application of laws to aggressor states. In summary, the criminalization of self-defense disproportionately affects women. This is why we need to modernize and clarify our self-defense laws. Reform will protect those who have lived, experienced, or are living with domestic violence. We need to advocate for the victims and survivors of domestic violence, trafficking, and the marginalized. The courts apply narrow interpretations of imminence, which creates a cycle of ongoing patterns of abuse. The current laws also focus on the single moment. One example of this can be seen in confrontations of domestic cases. Policymakers need consistency in the incorporation of trauma-informed views from self-defense claims. Specifically in self-defense cases, expert testimony should display the psychological effects of prolonged domestic abuse, trafficking, and abuse in general. Juries should be obligated to attend monthly educational mandated trainings and meetings. These programs will address the realities of disproportionality and the criminalization of self-defense to reduce the misunderstandings of survivors' actions as excessive or unreasonable. This is critical when these actions are shaped by lived experiences of imposed fear and the jeopardization of life. Key strategies of reform include a redefinition of self-defense standards, the implementation of judicial and legal training, a binding of international standards, and developing empowering support programs for victims. Furthermore, we can also increase women's representation. Legal training needs to incorporate trauma. Lastly, we can develop access to specialized trauma-informed therapy as resources for the victimized. My colleagues and I would like to thank you for your time and for the opportunity to share our findings. We appreciate this chance to express our concerns.
Thank you, Madeline and Kiara. Okay, so we will close with one more group of students who have been focusing their attention on exploring the human rights implications of immigration and domestic violence. We'll start off with Hayden. Are you ready?
Yes, can you hear me?
We can.
Perfect. Good afternoon or morning, everyone. Thank you for being here. My name is Hayden Malden, and I will be presenting my group's work on immigrant survivors of domestic violence and the intersection of human rights and immigrant enforcement. This issue is not just about law, it's about safety, dignity, and whether our systems protect the people they claim to serve. Immigrant survivors of domestic violence face compounded vulnerability. They are navigating gender-based violence and immigration enforcement at the same time. Federal immigration law does provide certain protections, most notably under the Violence Against Women Act and through U visas. However, systemic barriers such as visa caps, enforcement rollbacks, and shifting asylum precedents limit meaningful access to safety. Research shows that between 30 and 50% of Latinas, South Asian, and Korean immigrant women report experiencing intimate partner violence. Abusers frequently exploit immigration status as a tool of control. They threaten deportation, they withhold documents, they isolate survivors by using language barriers and misinformation about the legal system. At the same time, fear of immigration consequences discourages reporting. Recent reporting indicates that domestic violence victims increasingly avoid contacting law enforcement due to fear of deportation. Notably, after the Department of Homeland Security rolled back protections limiting immigration enforcement in sensitive locations such as shelters, hospitals, and courthouses. So while protections exist on paper, in practice, many survivors feel trapped. Under domestic law, federal immigration law governs deportation, shifting asylum eligibility, and humanitarian relief. The Immigration of Nationality Act allows deportation for certain offenses, including some domestic violence convictions. While this aims to promote public safety, it can also create unintended consequences. Survivors may avoid engaging with the legal system if they fear triggering immigration scrutiny. Congress recognized the vulnerability of immigrant survivors when it passed VAWA in 1994. VAWA allows certain immigrant survivors abused by U.S. citizens or lawful permanent residents to self-petition for legal status without relying on their abuser. This was a critical step in acknowledging that immigration dependency can be a powerful tool of abuse. U visas also provide lawful status to victims of qualifying crimes to assist law enforcement. However, the annual cap is only 10,000 visas. Meanwhile, pending cases exceed 250,000, while backlogs stretch 5 to 7 years. The gap between availability and demand leaves many survivors in prolonged legal uncertainty. They may have work authorization eventually, but they wait years in limbo. Gender-based violence claims are typically analyzed under the protected ground of membership in a particular social group. In 2014, the Board of Immigration Appeals recognized that certain domestic violence survivors could qualify for asylum when their home governments were unwilling or unable to protect them. This was a significant acknowledgement that domestic violence can constitute persecution. However, in 2018, that interpretation was narrowed, making it significantly harder for survivors to win asylum claims. In 2021, that restrictive ruling was vacated, reopening the possibility for such claims. The back and forth means unpredictability. It means survivors' futures may hinge on changing administrative priorities. Although domestic violence-based asylum claims are legally possible today, they remain procedurally unstable and difficult to win. especially given heightened credibility standards and expedited removal processes at the border. Moving on into international framework, international human rights principles recognize freedom from gender-based violence as a fundamental right. Under Convention on the Elimination of All Forms of Discrimination Against Women, commonly known as CEDAW, states have what is called a due diligence obligation. That means governments must prevent, investigate, and punish gender-based violence. Even when violence is committed by private actors, states cannot avoid responsibility if systemic failures of protection exist. The United States signed CEDAW in 1980, signaling its intent to support the treaty's principles. As a signatory, the U.S. is obligated under international law not to act in ways that defeat the purpose of the treaty. However, the United States has never ratified CEDAW. This means it is not legally obligated to comply with the treaty's core provisions to the same extent as countries that have formally ratified it. The Senate has not provided the required advice and consent, and as a result, the U.S. remains one of the few countries in the world that has not ratified CEDAW. International refugee law also protects the right to seek asylum and establishes the principle of non-refoulement, the prohibition on returning individuals to countries where they face persecution. The United States is bound by core refugee principles through its accession to the 1967 Protocol relating to the status of refugees, which incorporates key provisions of the 1951 Refugee Convention. This creates an obligation to ensure that individuals facing persecution, including gender-based persecution, are not returned to harm. Together, these domestic and international frameworks make one thing clear. Domestic violence is not merely a private matter. When a government cannot or will not protect survivors, it becomes a human rights issue. However, fulfilling these obligations requires more than statutes. It requires consistent enforcement, accessible protections, and a system that prioritizes survivor safety over immigration deterrence. Now I'm going to pass it to my peer, Cameron Harris.
Thank you, Hayden. There are several key recommendations that we believe are both practical and achievable for the United States to implement. Our provided policy brief presents 9 recommendations, several of which I would like to emphasize. First and foremost, we must ratify CEDAW, as it is currently signed, but the U.S. cannot be properly held accountable for discriminatory actions without CEDAW ratified. The U.S. should also codify domestic violence-based asylum protections. Congress should clearly state in statute that gender-based violence can qualify as persecution. This will prevent future administrative reversals and ensure stability in asylum adjudication. Furthermore, Congress should strive to amend the Immigration and Nationality Act to recognize that domestic and gender-based violence is grounds for asylum under the particular social group category. This will ensure consistency with international refugee standards. At the same time, we must reinstate and strengthen sensitive location protections. Immigration and enforcement should be permanently restricted in shelters, hospitals, and courthouses to ensure survivors can seek help safely. Limiting cooperation with immigration enforcement in cases involving crime victims promotes trust, increases reporting, and strengthens public safety. Expanding federally funded multilingual legal services is another recommendation. Survivors navigating VAWA petitions, U visas, and asylum claims need accessible legal and language support to meaningfully access protections. Expanding the U visa cap's annual limit as well would reduce the 250,000 case backlog and shorten multi-year waiting periods that leave survivors vulnerable. By incorporating the international due diligence standard, asylum adjudicators will evaluate whether a survivor's home country systematically fails to prevent or respond to domestic violence. This aligns the U.S.'s decision with the global human rights obligation under CEDAW. Simultaneously, we must strengthen international protections and burden sharing. The United States should expand refugee resettlement pathways and increase cooperation with UNHCR programs to support survivors of gender-based violence, reinforcing commitments under the Convention relating to the status of refugees. In conclusion, immigrant survivors of domestic violence are often caught between seeking safety and risking deportation. The intersection of human rights protections and immigration enforcement put them in a greater danger, even though these systems are meant to protect them. Although legal safeguards like VAWA and U visas demonstrate intent to protect, the gaps in capacity, clarity, and enforcement undermine their effectiveness. If we are serious about protecting survivors and promoting public safety, we must go beyond what we are doing now. We must stabilize asylum standards, expand humanitarian pathways so survivors are not left waiting in fear, and ensure that seeking help never results in punishment. Anything less leaves the most vulnerable at risk. Thank you all.
Well, thank you to all of the students for all of their hard work. Policy briefs created by these students and their working groups are available on the conference website. I have to say that every year when I do this and I get to listen to the work that these students have done, I am relieved and proud that they are the ones who will be addressing human rights in the future. So we leave you now. I know we went over time, but we leave you now hoping that you took something from this imagined community and that you were able to collaborate across divisions of class and gender and any number of other things. We will be posting these recordings, so please follow up with me if you if you have questions about that. And if you have questions for our Indian colleagues, I'm also very happy to respond to those. So thank you, everyone, and have a wonderful day.